So hi, I'm Alice Roach, and I'm a senior research associate in the Division of Applied Social Sciences at the University of Missouri. And joining me for this particular video lesson is Caleb Colbert, who's an attorney with the Haden and Colbert law firm. So this video is part of a project titled Marketing Opportunities for Missouri's Niche Meat and Poultry Processors. And in this video lesson, we'll work through some scenarios that will show how to apply the principles that were shared in an earlier video titled Starting a Business Risk Management to determine the right legal structure according to your business model. So thanks, Caleb, so much for joining us today.
Happy to be here.
Okay, so I have a series of scenarios here to share with you to try to help our meat processors in the state think about how they may approach legal structures in their own businesses. And to get started, let's assume that a meat processor has launched an e-commerce business to respond to the COVID-19 pandemic. And e-commerce represents an area where that business wants to continue its growth into the future. So what would be some advantages and disadvantages of operating that e-commerce enterprise as its own entity?
So I think sort of the primary advantage if you operated it as its own entity is you have the opportunity to bring in more investors. For example, if you think that e-commerce is something where you're wanting to expand, but potentially bring in more owners or involve more family members, that sort of thing. If you operated it as its own entity, you can bring in other folks without necessarily tying them into the parent company, if that makes sense. But obviously, you still have the additional advantages of you're protecting the assets of the parent company, you're protecting the assets of the owners of the parent company. So to me, you get all the benefits of that corporate veil that we talked about if you spin off the e-commerce enterprise with the additional flexibility of bringing in other folks that may want to participate in that venture, if that's something that you're exploring.
Yeah, great perspective there. So our next scenario here is assuming that a business has recently purchased some land adjacent to a current processing facility, and the business wants to expand the facility on that newly purchased tract of land. So one entity right now in this scenario owns the real estate, the facility, the equipment, the inventory, and the brands. To sufficiently manage its risk, how should the business approach separating its assets?
So typically in that case, I would recommend that they have each kind of unit of risk separated out into its own entity. So, in that scenario, there really should be one entity that owns the real estate, perhaps owns the building, and leases that to the operating entity. If you have, in that scenario, I would consider, sort of the operation, the processing to be the higher risk activity, in that particular business model. I mean, owning real estate is not necessarily inherently risky, but operating a processing plant where you're dealing with, obviously people, you're dealing with employees, you're dealing with customers, you're dealing with the general public. There's a certain inherent level of risk there that I would suggest you don't want to share that risk with the ownership of the real estate. You should be able to separate the ownership of the real estate out so that real estate is always protected. And the only person you have to deal with that on is the bank, potentially. If there's a mortgage on real estate, obviously you still have to pay the bank, but you don't want creditors of the operating entity to be able to get to that real estate asset. Because essentially, if we work out the hypothetical and we say, okay, someone's injured at my place of business, and for some reason there's no insurance coverage or the insurance coverage isn't sufficient, they get a judgment against me. They have a right to go out and satisfy that judgment and get paid by going to collect against my assets. And we want to move that real estate asset out of the reach of that particular plaintiff in that lawsuit. And the only way to do that is to have it in its own entity.
Thank you. Let's assume that a group of family members would like to partner in owning a new meat processing facility to respond to the shortage that we've seen of processing capacity throughout the state. So what are considerations if you're working collaboratively with others to start a business rather than you just starting the business as an individual?
Sure. So anytime that you're going to go into business with anybody, whether it's friends or family, you have to make some difficult decisions on the front end. You have to decide, okay, what are our initial startup costs and how are we going to share those costs? Once the business is up and running, How do we share the day-to-day management decisions of the company? How do we share when we get to a point where we're generating a profit? How do we share profit among the family and friends? And then if something goes wrong and we get sideways with somebody, how do I, as a member or owner of the company, get out of the company? What's my exit strategy? Or conversely, if there are issues between members, how do we force someone out? I mean, you hope it never comes to that, but ultimately those are decisions. I mean, those are scenarios that happen in real life. Sometimes folks change, circumstances change, and people need to get out of a company, or people need to be forced out of the company. And you really want to have those discussions on the front end while everyone's on good terms, and there's a lot of spirit of working together and trying to come up with a business plan that works for everybody. Because if you wait until there are problems, it's impossible to work those out once those problems exist. So you want to talk through, before you go into business with anybody, what are we putting into it? How are we managing it? And how do we get out of it? Those are essentially the three scenarios or three topics that you've got to decide on the front end. It'll avoid a lot of conflict down the road.
Sure. So those upfront conversations are helpful. What about having periodic sort of check-in or status meetings to determine whether the policies that were established upfront still fit with the business? Do you recommend something like that?
Sure. So let's take a limited liability company, for example. I mean, we typically include in our operating agreement that anybody can, ask for a meeting of the owners. And it makes sense, to have those at least annually. So everybody can sit down and, work through if there are any issues that have come up, how do we resolve those and get past them and get on down the road, that sort of thing. So we do encourage folks to get together, have meetings, and, have open communication about, their success or their unhappiness with the existing structure and the existing policies.
So communication is really key here.
Absolutely. Absolutely.
Right. Okay, so our next scenario is assuming that a business operates multiple enterprises that are structured as their own entities. So let's assume a business has catering, it's selling via a retail store, and it's also offering custom processing. To minimize some of those administrative costs that you mentioned in the previous presentation, the operators would like to share staff among the three entities. Is it permissible given that enterprises should operate separately? And what are some considerations for capturing efficiencies while you're operating those three separate entities?
So the entities can definitely share staff. However, they're also going to be subject to all of the payroll regulations, all of the wage and hour laws apply across the related entities. They don't apply just to each individual entity. So, for example, one staff person can't work 40 hours for company A and then 40 hours for company B and not get paid overtime. Essentially, the wage and hour laws are such that that person is going to have to get paid. If those entities are truly related, they'll have to get overtime for those extra hours. But generally speaking, there's no prohibition on sharing staff amongst those companies. But there will be some rules and regulations you do have to abide by.
Sure. So any thoughts about other opportunities for capturing some efficiencies there if you're operating three separate entities in this case?
If you have three separate entities, you really want to observe the corporate formalities to the best you can. I mean, where you're going to capture some efficiency is, working with the same accountant, working with the same bank, working with the same, financial institutions. To the extent that you can work with the same folks, that is sort of the intangible efficiency that you're going to capture. Obviously, again, if you share staff, that captures some efficiency right there.
Excellent, thank you. And our last scenario here is specific to assuming that a business owner wants to initiate that succession planning or estate planning conversation to position the business to easily transition to the next generation. So how does the business structure serve as a factor to consider in that conversation?
So the business structure factors into that conversation because generally speaking, regardless of what structure you form or what entity you form, there are going to be transfer restrictions in the governing documents for that company. So for example, a limited liability company has an operating agreement as its governing document. Typically speaking, if you have multiple owners, there are transfer restrictions which say, I can't pass my interest to a third party without offering it, to the existing members of the company, that sort of thing. So the business structure and the governing documents impact what you can do with your ownership interest in the company, at your death. And again, those are things that you can discuss on the front end when you go into the business, as far as it's not uncommon to allow, shares to pass automatically to a child, that sort of thing. So you can build some of those protections into the operating agreement or into the governing document when you set the company up. But those are things that you'll want to discuss as you're going into the business.
Sure. So in a lot of cases, a business may have started before there were heirs. So how do you add in that piece, after you've actually formalized that business structure to begin with?
Sure. So all of the corporate documents that you're going to encounter can all be amended. So again, sticking with the limited liability company, you can go in and amend the operating agreement to, change how the, membership interest will transfer on the death of a member. And the same would be true for a corporation or partnership. All of those entities have governing documents that can be amended if circumstances change.
Excellent. Well, thank you, Caleb, for sharing these insights, and thank you to our audience for joining us.
Sure. Happy to help. Thank you.